The power of the court to order a third party to disclose information to the claimant to enable that claimant to seek legal redress against a wrongdoer where, absent the information, such redress could not be achieved. It's important on several different levels. Firstly, it is capable of filling a gap in justice. Without the information sought, which is in the hands of the third party, the claimant cannot seek redress for the wrong committed against him. Secondly, it is a flexible remedy. Over time, threshold ingredients have been developed by the courts, on top of which there is a layer of judicial discretion. But the application of the principles is not straitjacketed or confined to particular fact patterns. In the words of Lord Woolf, new situations are inevitably going to arise where it would be appropriate for the jurisdiction to be exercised, where it has not been previously. In this sense, the Norwich Pharmacal jurisdiction is one of the best examples of judicial creativity in the last 50 years. People unfamiliar with the jurisdiction are surprised to find that a Norwich Pharmacal order sees through and beyond any legal duty of confidentiality which the third party may owe in respect of the information it holds. And so, a bank or even a lawyer can be required to disclose information about their clients if the circumstances justify it. Confidentiality is, of course, the flip side of secrecy. In the words of Lord Millet, secrecy is the badge of fraud. The Norwich Pharmacal jurisdiction has been used in numerous cases to reveal fraud in its infinite variety: stolen monies, secret commissions, diverted corporate opportunities, and other forms of dishonest dealing. Obtaining information held by third parties can be used forensically, for example, to establish who is the true beneficial owner of an offshore vehicle or trust, or to reconstruct money flows to prove that a bank account holds money which was ultimately paid from an illegitimate source, enabling the claimant to assert a proprietary right to recover the monies. Yes, in the same way that the English common law has been exported to other parts of the Commonwealth and the UK-dependent territories and so on, happily, Norwich Pharmacal principles have also found significant traction overseas. In places like Jersey, Guernsey, the Isle of Man, Cyprus, the BVI, Cayman, Bermuda, and the Bahamas, the Norwich Pharmacal jurisdiction is thriving. Similarly so in Hong Kong. There is, however, a separate, more complex question around whether Norwich Pharmacal orders can be sought from the English courts for service on a third party who is abroad. The courts have yet to adopt a consistent approach to this question, and nor has the extraterritorial reach of Norwich Pharmacal been fully tested in the appellate courts. You will need to read the book in order to appreciate the various ways in which a Norwich Pharmacal order can be deployed against a third party abroad. But the short point is that it is being done increasingly, and the cases which are most likely to get the blessing of the court are those involving serious and large-scale international fraud.